Welcome to Laws 13013, Legal Professional Conduct, Topic 9, Confidentiality. I'm Stephen Colbran. I would like you to take a moment and imagine a world where a client seeking legal advice could not rely on the lawyer keeping information confidential. Imagine you're seeking to obtain a patent for a new invention, only to find that the lawyer has tweeted the idea or made a Facebook post. Not only would the patent no longer be obtainable, but worse still, your competitive advantage would be completely lost. Imagine trying to negotiate a contract only to find that the other side knows all about you and what you'll accept as the minimum price. These couple of examples show just how important maintaining confidences can be. The reading for this module is Isaiah Ross, Ethics in Law, Lawyers' Responsibility Accountability in Australia, Chapter 11. When reading the material for this week, consider the learning outcomes that we're aiming to achieve. Namely, to identify 5 ways in which ethical problems can arise out of the legal practitioner's duty of disclosure, articulate and apply the duty of confidence as expressed in the Barristers and Solicitors Rules, identify 5 situations which may justify disclosure of client confidential information, and finally, to apply the principles of legal professional privilege in relation to confidential information. What then is the duty of confidentiality? In terms of a definition, the Butterworth's Concise Australian Legal Dictionary defines the duty of confidentiality as a duty owed by a recipient of confidential information, not to misuse information obtained by virtue of the recipient's relationship with the owner of the information, and to refrain from using the information for the recipient's own benefit or to the owner's detriment. The duty of confidentiality arises from 3 sources. Firstly, the retainer contract between the solicitor and the client. And this term of confidentiality may be either express or implied into these contracts. So said Lord Justice Diplock in the case of Parry Jones against the Law Society, 1969, 1 Chancery 1 at page 9. Secondly, there is a duty in tort to act with reasonable care in respect of client information. A failure in this regard may amount to negligence and result in a damages claim. Thirdly, equity also ensures that confidences are maintained by preventing further breaches, typically through injunctive relief. There is a fiduciary responsibility which prescribes that the lawyer must not use the confidence for his or her own benefit or the benefit of another client. There are also specific rules both for solicitors and for barristers. The primary Solicitors Rule is found in the Australian Solicitors Conduct Rules, Rule 9, Confidentiality. 9.1. A solicitor must not disclose any information which is confidential to a client and acquired by the solicitor during the client's engagement to any person who is not, firstly, a solicitor who is a partner, principal, director, or employee of the solicitor's law practice, or a barrister or employee of, or person otherwise engaged by, the solicitor's law practice, or by an associated entity for the purposes of delivering or administering legal services in relation to the client. Then there are some further exceptions in Rule 9.2, which we'll look at in a moment. With respect to the barristers, the confidentiality provision is found in Rule 108. You'll find similar provisions in relation to pupil barristers with respect to access to client files in Rules 110 and 111. But Rule 108 says that a barrister must not disclose, except as compelled by law, or use in any way confidential information obtained by the barrister in the course of practice concerning any person to whom the barrister owes some duty or obligation to keep such information confidential, unless or until The information is later obtained by the barrister from another person who is not bound by the confidentiality owed by the barrister to the first person and who does not give the information confidentially to the barrister, or the person has consented to the barrister disclosing or using the information generally or on specific terms. So there's a few exceptions there which will also, as we see a little bit later, apply in relation to solicitors. So what then are the circumstances when confidential information may be disclosed? There are essentially 5 of them. Firstly, where the client consents or waives the privilege by virtue of their actions. And this is found in Solicitors Rule 9.2.1. Secondly, where the disclosure is required by law, rule of court or court order. This is Solicitors Rule 9.2.2, Bar Rule 109. Thirdly, to defend a charge or complaint of criminal or professional misconduct. Solicitors Rules 9.2.3 and 9.2.6. Fourthly, where there is an overriding general duty, for example, the protection of others from serious physical or financial harm. Solicitors Rule 9.2.4, 9.2.5 and Bar Rule 81. And finally, where the information has simply become public knowledge, hence has lost its confidential nature. See Bar Rule 108. That then brings us to the concept of legal professional privilege, which you will no doubt have encountered or will encounter in several subjects in your law degree. The law protects information, including disclosures and confessions, as between the client and their lawyer. The protection or privilege is that of the client, not of the lawyer. Hence, the privilege can be waived by the client. The notion of privilege protects and prevents the disclosure of information. It covers both oral and written statements. Justice Lockhart in Trade Practices Commission against Sterling, 1979 36 Federal Law Reports at 244, gave examples of documents which would rightly attract the privilege, namely any communication between a party and their professional advisor, if it is confidential and made to or by the professional advisor in his or her professional capacity with a view to obtaining legal advice is privileged. The privilege also extends to communications and documents passing between a party's solicitor and a third party, if they are made or prepared when litigation is anticipated or commenced. The rule means that a lawyer cannot disclose to a court or to another information which is covered by the privilege. Legal professional privilege prevails over an obligation to produce documents on subpoena unless the privilege is cut down by some specifically worded statutory provision. In the case of Esso Australia Resources Limited against the Commissioner of Taxation, 1999 74 Australian Law Journal reports at page 339, the High Court by majority overruled the case of Grant and Downs and stated that the dominant purpose test, not the sole purpose test, is the common law test for claiming legal professional privilege. I expect students to read this case in detail. The original statement of the dominant purpose test is found in the minority judgment of Chief Justice Barwick in the case of Grant and Downs, 1976, 135 Commonwealth Law Reports at 674. In that case, Chief Justice Barwick said that a document which was produced or brought into existence either with the dominant purpose of its author or of the person or authority on whose direction it was made is protected by privilege. What then are the restrictions on this privilege, this legal professional privilege? There are 3. Waiver by the client. Apart from consent, there may well be implied waiver, where due to the conduct of the client it becomes unfair to maintain the privilege. An example may be where there is a complaint to a professional body about a solicitor's behaviour. And that example can be found in the case of Goldberg against NG, 1995 185 CLR at page 83. The second way the privilege can be restricted is through statutory abrogation. In Federal Commissioner of Taxation against Citibank Limited, 1989-20 Federal Court Reports at 403, there was a broad statutory right to enter, seize and copy documents under the Income Tax Assessment Act, section 263. This was held to be subject to legal professional privilege. The actions of the tax office were held to be invalid. The words of the statute must be clear, very clear, to abrogate the privilege. The third restriction on the privilege is that of public policy, namely improper or illegal purposes. Legal professional privilege does not attach to communications between clients and lawyers which are founded on some improper or illegal purpose. In Australian Federal Police against Propend Finance Proprietary Limited, 1997, 141 Australian Law Reports at page 545, the Australian Federal Police argued that a communication in furtherance of a crime or fraud should not be privileged. Justice Colbran said, "If you have documents which relate to activities, criminal or otherwise, of the past, then the privilege would attach to those documents. That is the whole essence of privilege, to give you a proper defence to those charges. What it does not protect is information or advice given in relation to the commission of future crimes or wrongs, because that is not necessary as part of the rationale of the privilege to serve the due administration of justice." You should also take the time to read the test enunciated by Gummo in the same case. So, from studying this topic, you will have gained an understanding of confidentiality and legal professional privilege. Maintaining client confidentiality is critical for establishing and maintaining lawyer-client relationships, the protection of valuable information, and maintaining the due administration of justice. The ethical rules in relation to client confidentiality are strict, and practitioners need to be ever vigilant that they comply with them. This concludes Topic 9, Confidentiality. Next week we will be considering Topic 10, Conflicts of Interest.